So this is revision against order of framing, petition against the order of framing of charge. Revision has been dismissed. The point is, my lord, is very small. Kindly come to the FIR, my lords, which is on page number 26. Charge of 406.
Page number
26.
Yes.
फरियादी चंदन सिंह वर्मा पुत्र सुवनसो निवासी सुवनसो ने उपस्थित आकर जुबानी रिपोर्ट किया कि मैंने दिनांक 3/4/19 को नरेश रावत पुत्र रामस्वरूप रावत निवासी दरौनी थाना सिरसौद को एक मारुति स्विफ्ट VDI नंबर सुवनसो चेसिस नंबर सुवनसो रंग सफ़ेद 4,30,000 रुपये में काली सोनी की दुकान पर काली सोनी के सामने खरीदी की थी, जिसका नगद भुगतान कर दिया था, जिसकी लिखा पढ़ी नोटरी शपथ पत्र पर की थी, जिसका RTO में ट्रांसफ़र होना था। दिनांक 25/9/19 को नरेश रावत मेरे पास आया और बोला कि मुझे मेरी ससुराल में गमी हो गई है, मुझे जाने के लिए मुझे अपनी कार दे दो, और मेरी कार लेकर चला गया। जिसके बाद दिनांक 26/9/19 को नरेश मेरी कार लेकर वापस नहीं आया। उसके बाद मैंने नरेश के मोबाइल नंबर सो पर फ़ोन लगाया तो उसका फ़ोन बंद जा रहा था। इसके बाद मैं नरेश के घर गया तो वो घर पर नहीं मिला, इसलिए नरेश रावत मेरी कार लेकर भाग गया है। Now, admitted fact of this case, I am Naresh Rawat. Admitted fact of this case is that, my lord, there was no sale has taken place. In the registration stands in my name, the insurance stands on my name, and as per the definition of owner under the Motor Vehicle Act, it is the person who is having the registration card.
What is the allegation against you?
They say that I agreed to sell him a car. I gave him possession, but thereafter I have taken back the car and I have not returned it.
Has the other person paid you the money, the consideration?
They say that it is in cash.
That's
But then
they will have to show. They will have to.
But, my lord, a person who is a true owner, he cannot be charged for breach of trust, because I am owner of that property.
You are undoubtedly the de jure owner of the vehicle, undoubtedly. But where the complainant has stated that you have entered into an agreement and that you sold the car, he has given you cash for it,
But
and that you handed over the car to him,
yes,
and then taken the car from him for the purpose of temporary usage of the same.
yes.
Then we can only go by what the allegation is there.
But
is
they-
420 also.
No 420.
Only 406.
Only 406. But I am my humble submission before
That everything, because it is registered, you have not gone to that stage.
that is what, my lord, I am till today I am the owner. Now owner cannot be charged for breach of trust, my lord, because there is no entrustment to him. As of now, I am the owner.
There is entrustment.
No, because he also says that there is no transfer of ownership. If your lordship may kindly see this decision of Honorable Apex Court.
When we are at the stage of framing charge,
Yes, my lord.
at the stage of conviction is totally different. We will have to go through whether we have.
Even at the time of giving supurdgi of the vehicle, I was considered as the owner of the property.
That is because the court will there say who is the registered owner. That
Yes.
is all, not the actual owner.
No. I will be the actual owner also as per the
Understand
definition.
That you will be considered to be because the name of your name is
Yes.
there in the records of the
Yes.
RTO.
Yes.
That is all.
Yes.
Here there is another aspect. Here he says that you told him that you will sell your car to him.
Yes.
You took the money from him.
Yes.
And then he says he handed over possession to me.
Yes.
And then later on some pretext he borrowed the car.
And then have
and
not
thereafter
returned.
he is not returned.
I have not
You
returned.
returned.
I have not returned.
So and he has asked for it.
So
and then
for
you have
breach of trust, my lord, there has to be entrustment of his property to me.
No, that is what he's saying. If it has been sold, you can't take you can't take this thing, the benefit here of cheating man. Then I'll say it's a case under 420.
But the prosecution has not made the
Then
case.
because he's made an allegation. If you are saying you will go from the frying pan into the fire, 206 maximum is 3 years.
Yes, my lords.
420 is up to 7 years.
Yes, my lords.
Now, whether the allegations make out an offence is what the court has to say.
Yes, my lords.
The allegation would certainly make out an offence. Now, if it is not 406 because you say this thing is done under, that's a case of 420.
My
The
lord,
minute
then
that 420 is 406 is squashed, the court is to re-examine whether 420 is made out on these grounds.
but my lord, as of now, 406 would
Can't
not
take
be.
the benefit.
No,
Where
what-
if his allegations is correct, then certainly there is an act of cheating on your part, because there was never any intention on your part
To give
hand
away-
over the car.
to hand over the car to
because
him.
You fooled the man.
But I cannot be charged for 406, my lord,
you
because
asked them to charge you for 420.
what my humble submission, there may not be any direction for that.
482, what is the ultimate aim of the court? To ensure that substantial
Justice,
is done.
no miscarriage of justice may
So
take
if,
place.
yes, there's a miscarriage of justice. We feel that 406 is a miscarriage of justice. Then 420 is the correct section.
But your lordship may not issue the direction to the trial court.
We do that because ultimately interest of justice demands
Direction,
that.
if your lordship will issue direction, then certainly I will be hanged in for 420. But for 406, my lord, may I kindly consider this fact. If even at the time of granting of Supurdgi also, and even as on today, my lords.
See, ultimately we have to see Supurdgi and all. The court is only supposed to look into whose name is the vehicle registered. That is all. Now you have not, according to him, you have not crossed that stage where after receiving money, it was your duty to transfer that car in his name.
No, it is his duty, my lord. He is the purchaser.
He is a purchaser, he should have done, but so that the NOC has to come from you.
So that documents, they say that I have signed those documents. Kindly see, they have placed on record that as well. But they haven't done that.
If they have not done that, then it prima facie makes their contention strong that the money has been received by you.
No, my lord. What my humble submission is that, my lord.
Why did you give him NOC that you have no objection of him getting the vehicle registered?
There was an agreement, but due to some dispute, now he has not tendered the money. That's what I was instructed to
I
submit.
understand that, but the fact is that NOC is always signed after receiving the consideration amount. Never before.
But as on, my lord, if we go by the definition, book of statute, my lord, of the owner, definition of the owner as per section 218 of the Motor Vehicle Act.
We are not going into the ownership, whether there was criminal breach of trust.
So for breach of trust, the property has to be of the complainant, my lord.
It has to be. But
So-
then whether there is a prima facie opinion that can be found that de facto he became the owner upon giving you the consideration of 50,000 or whatever
Right.
the X amount.
Yes,
for the vehicle.
yes, ma'am.
X amount. De facto he became the owner. All that was required was the legal formalities.
My lord,
You can't take the benefit of
the-
your illegality.
This-
by
this-
saying that
this
the
very-
law is in my favor.
this very question, my lord, came up in motor vehicle cases where these kind of transactions take place and then the accident takes
This is
place.
not under motor vehicles, this is
So
a
the
criminal
apex
case.
court said that the person may have possession, the person may have agreed to sell,
You
the
want to
person may
rely on
have.
that judgment, we'll deal with it.
No,
We'll
ma'am.
deal with it.
No,
Otherwise,
ma'am,
you
that's-
withdraw and take a chance before the trial court at the end of it. But the fact is, if he has put up NOC which is signed by you,
My lord, they have kindly see this document which they have
yeah, that's
placed.
there on page number
Page
50.
47.
47.
47.
It's
47.
there. Those documents are there.
Yes, but the still the vehicle stands on my name.
It may be. That's why I'm saying there's a case of cheating, not 406.
But this is
You've
not the
taken
case
the
of
man's
fraud.
money, you've given him a sale letter, everything has been signed by you and you've taken his vehicle.
Now the prosecution has not come up with section 420 against me, my
We
lord.
will make that observation. We'll have to make that observation. The trial court has gone wrong. It is for us to correct it.
But even
is
in,
for us to-
with due respect, my lord, even in revisional jurisdiction, there cannot be any direction.
No, we can at least give the court a hint.
For hint, my lord, I have no objection, but if your lordship may not give the direction, then
No, this is not. I would say it's not a fit case because once he's paid the money, you've done everything.
my lord, that
Given a
payment
possession,
of money,
only-
that payment,
only the fulfillment of a legal formality.
that
Can't
is the
make
case.
use of that. You can't make use
Well,
of
that is the main thing, that unless and until it is transferred, like in the case of sale.
You argue, you give me the judgment, you pass an order on merits, right?
My only submission, my lord, that 406 may not be made
I'll
out
tell
in
you
these.
how it's made out. You give me an occasion, I'll give it to you in 5 minutes as to how the 406 is made out.
I may be granted liberty to.
Well, if the counsel for the petitioner wants to withdraw this petition with liberty to take all the grounds in the petition before the learned court below. Full stop. The petition is dismissed and withdrawn. Liberty is approached.